Bob, I'd like to talk with you a little bit about the professorship in Catholic thought at the University of Toledo, and I want to draw on your specific expertise, which is in the area of constitutional law. And you are a unique combination of being a Catholic priest and someone who teaches in our law school. I don't think that precludes your participation in this discussion. In fact, I see it as enriching it. And so I'd like to talk a little bit about that from a legal viewpoint. I might need to say something about the professorship in general to begin with so we know what we're talking about. At the University of Toledo, we now have a professorship in Catholic thought. It's named the Margaret and Thomas Murray Professorship through a donation from Tom Murray, a lawyer in Sandusky, honoring his parents. And the general idea is that it is to bring into the university setting experts on the Catholic tradition to teach 2 courses during a given term on some recognized aspect of the Catholic tradition. That, in broad outline, is what we're talking about here. Now, that raises some controversy, and some people seem to wonder about the legitimacy of this, especially from a legal viewpoint. So I wonder, with just that bit of background, if you might want to jump in here and begin to comment on this and from out of your own perspectives.
Sure, there are a number of angles to it. One of the things one would hope for anyway, and I believe that you've had this in mind, is that this might inspire other religious traditions also to try to establish similar professorships to study the contributions that all of our many religious traditions have made to American society and life and thought.
Can I pick up on that, Bob?
Sure.
We made explicit effort along that line from the very beginning, from many years ago when the concept was established of having this professorship in Catholic thought. I made contact with other religious groups and made sure they knew what we were doing and explicitly encouraged them to try to develop their own lectureships, professorships, or maybe even chairs. I must say that at various times we have gotten hints that groups might want to do this, and we're hoping that happens.
Yes.
And I think that would give a much more rounded opportunity to explore the world's great religious traditions.
I think that that's only fair because, of course, there's been a lot of cross-pollination of thinking and experience in the different religious traditions that make up our background, and it certainly makes sense. And it's that kind of approach, by the way, which I think holds the key to the constitutional solution to the problem. People talk, for example, very glibly about the separation of church and state without really giving an awful lot of thought to the implications of that and without trying to follow the at times tortuously turning course that the Supreme Court has followed in laying down the meaning of the constitutional provisions with regard to religion and religious exercise and the establishment of religion. But it seems to me that it's quite clear that as long as you have an object of study that you can look at objectively, you're going to be talking about something which certainly falls within the protections of the Constitution and doesn't violate the separation of church and state. The first point I'd like to make, and I think it's an important one, is that I noticed in the paper the article about the thing most recently talked about the...
This is an objection to the professorship in
Yes,
Catholic thought?
That's right. And talking about the idea of the separation of church and state. Well, the point is that the professorship, and I think I understand this quite clearly, is not anything that is operated by a church, nor was it begun by a church. It began with initiatives that came from a person on the faculty of the university, yourself, and aroused a great deal of interest and support from a variety of private persons. In no way at all that I can see is the church involved in it. And of course, when we talk about the university, we're talking about the state in the sense, of course, of government of a public entity that now falls within the restrictions of the Bill of Rights.
But Bob, would it be good for me to say some of these clauses directly in the contract to buttress your point? In other words, you were making the point that the church doesn't run this. I might just point out that what has happened is that interested people have contributed a large amount of money,
Yes.
about $450,000 towards a projected $500,000, have contributed that money, and that money then has been handed over to the university, given to the university under a contract. And just one provision in 11 articles in the contract says the professor shall be appointed by the university in accordance with the general procedures of the university, with all funds to come from the endowment. In other words, this money is now given to the university. The university is in total charge of it. The Catholic community no longer has any say in what happens except for the contract that governs it, which says that the professor who comes here is to be an expert in the Catholic tradition.
Yes, although that would allow for an expert who was not himself Catholic. I noticed that Martin Marty, who is a prominent Protestant theologian and church historian, is coming in your series this spring.
That's right. He's part of a 9 guest lecturers coming, and is probably the most prominent Protestant thinker in the United States. And the contract is very open to that. Mm-hmm. That is, the person is to be an expert in the Catholic tradition, but it is assumed that there are people in other traditions, in this case a Lutheran historian, who indeed does know that tradition and is able to speak to the general topic of the course, which is Catholic thought on cultural concerns. And since he's editing a 5-volume work on fundamentalism, which is his topic, it's a wonderful opportunity for him to try to bring together that cultural concern, how do we deal with fundamentalism, and using the Catholic tradition to look at it.
Yes, yes. And I suppose that it's also quite possible that a person whose emotional response to Catholicism might be negative, but would nonetheless be scholarly and in his ability to criticize aspects of the teaching of the Church, the position of the Church with regard to the sorts of issues that may arise, to be appointed by the university.
Yes, it definitely envisions that possibility. In fact, I must say, I was talking to one of the lecturers coming for this coming term, saying that she intended to be extremely critical of the Catholic tradition. Her general topic was on the roles of women and so on. Mm-hmm. And one can, by reading the papers and understanding some of the debates going on in the Catholic community, recognize her very diverse views. And she pointed out she was going to take a very critical stance vis-a-vis the Catholic tradition on the role of women. So this is, it plays into your point there that this is an academic study. It's an objective study of a tradition and what it has to say about particular cultural concerns.
Surely, and the part of the legitimate public purpose of a university is the study of all of the different kinds of influences and reality with which we have to deal, so that it meets the first of the Supreme Court so-called Lemon test, which is to
tell me more. Where do we get this word Lemon test?
Well, there was a lawsuit several years ago. I think it concerned the purchase of textbooks in secular subjects for private schools by one of the states, and it was challenged by a taxpayer on the grounds that it violated the separation of church and state, that it was tantamount to an establishment. Well, there were 2 criteria that had been floating around in Supreme Court jurisprudence for some time. They really owed a great deal of their prominence to the work of a law professor, Philip Kurland, at the University of Chicago. But the first of them was that a state action, to be legitimate, had to have a legitimate secular purpose, a valid public purpose that was not religious and was not involved with the projection of religious position.
Were they talking about like at the high school level with this, or was this?
I don't remember
general?
Whether it was general. I think it may have been.
My
grade school
recollection
or high
is
school.
it's not dealing with the university level, but anyway.
No, well, that's a different kind of thing,
right,
in a way.
It is indeed.
Although the essential point, the buying of books, did not involve the idea of influencing the children directly. Yeah. Which, of course, it makes part of the difference between the court's attitude toward college students or university students on the one hand and their institutions, and high school or grade school students on the other. But
let's get back to your point. Yeah, this Lemon test.
This involved just the business of buying textbooks that in, for example, geography and science and mathematics, things like that, were not subject to religious coloring. And the second point of the Lemon test, the second criterion, or the second prong, if you will, is that that what is done by the state must neither advance nor inhibit religion. It is to be religiously neutral. Mm-hmm. Now, in the Lemon case, Chief Justice Berger added a third prong that constitutes the so-called Lemon test. He wrote the opinion of the court, the decision of the court in the Lemon Kurtzman case, and he said that it must not lead to undue entanglement between church and state.
Entanglement becomes a key word there.
Yes,
then, right?
that's exactly so. So that you've got those 3 prongs. First of all, a valid secular public purpose. Secondly, it does not either inhibit or foster religion. And third, it does not lead to excessive entanglement between the church and the state. Now, I'd like to point out, before I go on, there have been some modifications of the court's thinking in very recent years about those
About
criteria.
when was this Lemon test? Do you
Oh,
remember
golly.
exactly?
You're asking me the kind of question I don't remember.
Yeah,
I'm going to say 15 years.
Okay, yeah. It's been around a long time. When you read the articles on this topic, it's constantly mentioned.
Sure, but that's only because the Supreme Court's moving with so many cases in this area that it very quickly gets pushed back in the line. It isn't necessarily that far back. None of these cases really came up until the Jehovah's Witnesses cases, only about 1940. Before that time, there were very few cases that touched this whole area of the First Amendment religion clauses. But the thing about the Lemon test that I think is vitally important, you clearly have state action in the university offering a course in Catholic thought. Secondly, it is, as taught objectively, looking at the phenomenon of this influence in the intellectual life of the West for many centuries. It is something that does not advance or inhibit religion. It is not proselytizing. It isn't supposed to make converts of people. It is simply exploring this important area of Western intellectual tradition. And the third thing is it doesn't involve any entanglement or the prospect of any entanglement because the church is not the sponsor of it. The church does not name the professor. It does not provide the money. It doesn't do anything of that sort. It has no real control.
It originally provided the money, but now the university has the money as an endowment, and that the interest from that endowment, $450,000, is used to pay for the professor and for the courses.
Yeah, but even the church didn't provide the money. I think there was perhaps a contribution, but most of the money comes from a private person who happens to be Catholic, but he's not the church.
That's well said, and that really ought to be clarified. Good point. I mean, this is all gotten from private individuals, and given who are citizens as well as being particular members. In fact, we did get contributions from people who are not Catholic too. So that would even strengthen your point, I suppose. Bob, let's make sure we have the overarching thing here. We're talking about a First Amendment question, right?
Yeah,
and the First Amendment's got two clauses.
That's right.
You know, we have the
first clause is the Establishment of Religion clause. The Congress shall make no law respecting an establishment of religion.
Yeah, very brief phrase, but very telling in our history.
Sure, and as a matter of fact, the one point that's involved in this question of the professorship in Catholic thought turns on whether or not the university, as a state institution offering that course and establishing that professorship, is doing something tantamount to an establishment of religion.
Right.
And
of course, our claim has been that it's not an establishment of religion.
And as a matter of fact, if the university were to turn down the proposed ordination and the request for the establishment of this professorship, the question is, would that not infringe upon the second of those clauses, which would be to limit or to prohibit the free exercise of religion? You've got some people who are inspired, for example, by religious motives, to see to the teaching of this aspect of tradition and its study as a university subject, and they want to contribute to it, and you say, well, no, you can't do that kind of thing. The two clauses actually work opposite one another. If you take an expansive view of the Establishment Clause, you're going to narrow the sense of what the free exercise means, and if you take an expansive view of free exercise, then you're narrowing the Establishment Clause to a very smaller compass. But I think it's important to keep in mind the idea that what we're looking at here is really the university doing something that falls entirely within its province. You have that free exercise business with regard to a lot of other things, too. I can be moved, for example, to be concerned about crime in the streets. I can be moved to concern about poverty in the city and its effects on housing and nutrition and health care and so on for the poor. All of them done not only because I think it may be a good thing from a civic point of view, but I can be inspired to do that by my religious motivations, and that doesn't make what I do in consequence of that inspiration a religious action. It's not an establishment of religion in any way, shape, or form.
So we've got these three criteria in the so-called Lemon case, and when you look at those three criteria, you see that you think that the professorship does not violate those.
That's right. And as a matter of fact, the important point is that the problematic is not that of church and state. We've seen that the church is not the counterpart to the university in the establishment or the operation of this professorship. But we're talking about a larger thing which has been insinuated into this whole topic in the last 35, 40 years, and that is that church has been replaced by religion. Now, the golly, back in about 1908 or 9, Justice Peckham, writing for a unanimous court, pointed out something that has been denied by individual justices since on occasion, and that is that the term establishment of religion in that First Amendment is a term of art. It's a legal term, and it is not equivalent to religion by itself. In other words, an establishment of religion is an organization, and that's what at least the original intent would seem to mean. Now, many of those people who say, no, that isn't what it means because we've read what James Madison said or Thomas Jefferson said or what somebody else said about it at the time, and it means just religion, that Congress isn't supposed to do anything at all about the religious inspirations that lead people to do certain kinds of things, including the religious expression. But the difficulty with that is that you can't have people who repudiate the concept of original intent in the interpretation of the Constitution on the one hand, and then assign a great deal of authority to something that James Madison had to write in 1791 or in 1811 or in 1834, 35, and you can't consistently take both those positions. Certainly the wording of the Constitution and the amendments in the Bill of Rights was very carefully worked out by very good lawyers who spent a lot of time debating exactly what they wanted to say and how to say it, and then it went out for the approval of the people all around the country who, for a variety of reasons and against a variety of different backgrounds, said, yeah, that's what we believe in, that's what we want our government to be limited in respect to.
Bob, one way this is often talked about is the difference between teaching religion and teaching about religion.
Yes.
There's a case, Abington versus Schempp. I guess that's commonly called the Schempp case.
Yeah, that's right.
And where Justice Clark said, he said, in addition, it might well be said that one's education is not complete without a study of comparative religion or the history of religion and its relationship to the advancement of civilization. It's one of the quotes from his opinion. And out of all of that, what came this general distinction that I think has guided much of what we've done in the public high schools, for example, and also within the university community. The notion that we could teach about religion, but not teach religion in any sense that it would indoctrinate or elicit to make a commitment to it and so on. And I think in the professorship in Catholic thought at the University of Toledo, that has been very explicit. I myself coordinated the first course and brought in various guest speakers, and they were all instructed to be careful of this. And in the syllabus, it clearly says that this class is not for proselytizing, it's not for witnessing, it is for the intellectual exploration of a given tradition. We were talking about current trends in Catholic thought was the first course taught in this connection with this professorship, and so that the professors were called upon to summarize what was going on in particular areas of Catholic thought, in the moral area, for example, or what's being said about Christ and so on. So it seemed to me that there was a very clear effort to teach about religion, but not religion in general, about a very particular religious tradition, that is the Catholic tradition, which is part of what has helped shape Western civilization and some of the ethos of our own country.
Yes, well, of course, that raises the point that's implicit in two other criteria that the Supreme Court has been looking at for judging whether or not state action violates the First Amendment, and particularly the Establishment Clause. The second of these two was proposed by Justice Kennedy. It hasn't enlisted a great deal of support among the other justices so far. It came out in some cases that came up in Pittsburgh a couple of years ago about a creche, a Christmas nativity display in the courthouse of Allegheny County in Pittsburgh, and outside on the lawn, I believe, a menorah that was set up to mark the occasion of Hanukkah. And Justice Kennedy proposed that the criterion the court ought to keep uppermost in mind in looking at these things is the idea of coercion, that if there's coercion, and he took that in a very broad sense, not in the sense of twisting somebody's arm and compelling them to do something by physical force or economic force, but coercion in the sense of creating a current of fashion that would carry people along, sometimes against their best interest or best instincts. And I think that very clearly this criterion does not really apply to to the professorship in Catholic thought.
Don't you think there's a difference here, Bob, too, in the age level of students when you're talking about coercion?
No, I think that's the other one, Jim. I think that you've got to keep that in mind, that's the endorsement thing. So let me get to that in a minute.
Okay.
Let's talk about coercion. The fact
is, I mean, you could, even from that viewpoint, you could say, college students who are in a classroom have a much better opportunity to think for themselves and not be subject to certain pressures.
But there again, I think that's fairly clearly endorsement that you're talking about there, and that's the other one I wanted to get to.
Okay.
Let me finish coercion. Okay. Students don't have to take the course. It's not required, as far as I know, in any degree program.
It's true.
They are entirely free to elect the course or not as they choose to do so, and so that one can hardly say it's coercive. And even if it is a fairly popular course, one can hardly say that there's such a current on that campus. I think we're both aware of that people are carried along and into the course whether they willed it or not.
We were very happy with the course. We had 110 students who took the first course for credit, and we were very pleased with that. But as you pointed out, it is totally an elective. It is good for humanities requirements, which is a happy event from our viewpoint, and students can apply it to that. But it's totally elective.
Yeah, there are alternative courses that they could apply to the humanities component of their degree program. Okay, now the other thing is Justice O'Connor has elicited a great deal of support from the court for what she calls endorsement, and this came up also in a Christmas crib case that came out of Rhode Island several years ago, Lynch versus Donnelly, and she argued that if the state's action is going to be read by people as an endorsement of a particular religious position or religious tradition or religious doctrine, that it should be prohibited. And
go back over that again. If
the state action is going to be understood or read by the average citizen as constituting an endorsement of a particular religion,
now our word is endorsement.
The key word there is endorsement, and this is, I think, where you have to be careful with regard to the insistence that this is a course that looks just at the academics, and that it is directed to college and university students who are supposed to have a level of maturity so that they are not easily swayed by propaganda or by leaping to conclusions about the implications of a particular course of public action or something of that sort. That's what I think is very important to keep in mind there. Now, the court, I think, is not deserting it. The Lemon test, I think the court is simply adding to its panoply of arms in terms of facing questions of establishment of religion and free exercise as it adds these concepts of coercion and endorsement.
Yeah, you really end up with sort of 5 criteria now that you have put forward here that we should look at.
The court is
3 from the Lemon case, and then these other 2 that have developed more recently, the coercive factor and the endorsement
factor. That's right. The court has never been shy about adding arms to its armory, and so that I think that that's a natural enough thing. But I
think we would also say that we really do not have, therefore, a Supreme Court case that directly takes on the kind of questions raised by the Professorship in Catholic Thought at the University of Toledo. Would you say that's true? It's more indirect. In other words, for example, we go back to that Abington case. They were dealing with a high school situation and whether they were going to read verses of the Bible at the beginning of the class time. And then the other example used about buying textbooks. I mean, it's oblique in a sense. It's not directly dealing with the kind of case that we have here.
Yeah, every fact picture, of course, is going to be different in one way or the other, and so that does come along in a variety of fashions. I think, though, that
I don't think we've ever had a challenge. You correct me on this. To religious professorships on campuses. Like we have many Judaic chairs around the country. We have a whole Judaic department at the University of Massachusetts, a public institution, for example.
Sure.
And we have examples of where there are endowed professorships on a religious topic. Now, as far as I know, there's not been a direct challenge to the existence of any of these chairs or professorships or departments at state universities.
I can't say that there hasn't been a challenge. There may very well have been. I would suspect that there has been, but I don't think it ever rose to the level of Supreme Court review. The 2 cases that come to mind that bear on the difference between grade school and high school students on the one hand, college students on the other, are first of all the application of GI Bill benefits, for example, to seminary students who came out of military service and wanted to go to the seminary, and that was judged to be legal. And The other one that comes along was the idea of government grants. It came up in the University of Maryland, or rather Maryland case in a Catholic college, I believe, and the borrowing of government funds at a very advantageous rate of interest in order to build a dormitory.
Bob, this is an ongoing discussion because the professorship at the University of Toledo sponsors courses each year according to the contract, and there's another one coming up in the spring of 1993 on March 30th, beginning a course entitled Catholic Thought on Cultural Concerns. And, of course, it's open to the public to come to on a continuing ed basis at the university and through registering through that department. And so it becomes sort of an ongoing question. Each time the course is raised, some people want to broaden the discussion and say, what is this about and is it legal and so on. Mm-hmm. And I guess what you have done for us is to, your own opinion as a scholar and teaching within our law school, is that when you look at the criteria and the way the professorship is being run, it appears to be constitutional to you. Mm-hmm. Someone could easily say, well, you're a Catholic priest, of course, but since you've been critical in other matters of what church does and so on, that might sort of enhance your credibility. But that is your fundamental position, as I've been listening to you, right?
Yes, that's right.
No matter what the criteria, whether it's entanglement, you don't see that. You don't see coercion, right?
Mm-hmm. And certainly I don't see endorsement either because of the maturity of the students with which we're dealing.
That's well said. Bob, thank you very much. And it helps to highlight this important question of the professorship in Catholic thought and exactly how we are to understand it and as it's actually lived out at the University of Toledo.